Hi, everyone. Welcome to the Insider panel, the Insider Industry Insider panel. Today, I am April Udy. We have wonderful panelists who have agreed to speak on their products. Today, we are joined by, Paulo Arredondo.
Perfect.
He's the co-founder and chief product officer at Casetext. He graduated from Stanford Law School and is a member of both the New York and the California State Bar, so yay for him. Prior to turning to legal informatics, he represented a leading technology companies, in patent litigation, both in the district court level and the appellate level. He's been awarded a lot of awards, including the AALL New Product of the Year Award, which was Cara. I hope I said her name right. His academic work also includes a fellow at the Stanford Center of Legal Informatics, which is focusing on identifying and leveraging patterns in judicial opinions. Did I get everything right?
That's perfect.
Awesome sauce. Our next panel is, sorry, I have a cold, is Michael Sanders. He is the founder and the managing director of Docket Alarm. It's a legal research and analytics company which was acquired by Fastcase in 2018. This is correct?
Sure, yeah.
Using big data analytics, Docket Alarm organizes unstructured legal information to support legal decisions. Docket Alarm has also won a lot of awards, and its customers includes many AmLaw 100s, university, and Fortune 500 companies. Prior to Docket Alarm, see if I got this right, Michael was an associate at a top-tier IP boutique law firm, which was in New York. He focused on patents, trademarks, and copyright disputes. He was previously a software engineer, and he has his engineering degree from Cornell and Santa Barbara, and his JD from Cardoza. He's a New York native, and he still lives in New York because they rarely leave.
We can.
And lastly, we have Kerry Kasim. He's an attorney and product manager at LexisNexis. Kerry develops products that apply machine learning, natural language processing, and AI principles to solve legal problems. He also helps develop APIs, which is application programming interfaces. I had to look that up. And platforms for consumers of legal data in government, industry, and academia. As a part of Ravel business, before his company was acquired by LexisNexis, Kerry drafted and negotiated license agreements and sales contracts with customers and strategic partners, and managed the institutional sales unit. Is that correct?
Spot on.
Yes. Prior to working in legal tech, he represented a growth business in both litigation and transaction in tech, commerce, and corporate governance. He is a member of the California State Bar and is committed to pro bono advocacy. So please welcome our panel. And I think we'll start with Pablo. Give us a rundown of updates and interesting things going on with Cara.
Okay, yeah, sure. So first of all, thank you guys so much for having us. It's great to be here. And the work that we do at Casetext is anchored in a belief that the ideal way to do legal research is to do it with technology that's cognizant of what you're working on. And that there's no one-size-fits-all results. Rather, you want results that are tailored to the nuances of your case. And specifically that those nuances are encoded directly into the litigation materials that underpin all litigations, be they the complaint or the briefs. The tool Cara started as a tool where you would simply drag and drop a brief, and it would suggest cases that are not cited in the brief already, but that are highly relevant to the brief. Some of the folks in this audience were among the very first people to ever see that, and then saw it also when it started really working, which is always nice to see a product do. And we've since then expanded the approach to a full-fledged legal research engine, so that not only can you drag and drop and have cases suggested, but any search that you do, it will tailor the results specifically to what you're working on. And that includes the citator, right? If there's 100 cases that cite your case, how do you know which one to look at? And so Kara is now beginning to sort of, every word that you might want to do context, Kara is now providing that. Which of the many summaries of a case would you want to show to the user when they're reading results, for instance? Like which snippets that contain a keyword would you want to display on the result list? There's really a lot that you can do once you have a system that pays attention to what's going on. And so that's sort of the brief history. In terms of where we're going, I think that Kara right now is side agnostic, which is to say it doesn't know if you're representing the patent owner or the alleged infringer. It doesn't know if you're representing the landlord or the tenant. And I think as attorneys, we know that, look, we're in an adversarial system. And while it's useful to have tools that can bring you just relevant stuff generally, it would be even more useful to be able to bring you stuff and organize it based on whether or not it helps or hurts your cause. Not that you don't have to read both, of course, but that it's useful to have those segregated. And then the other sort of progress we're making in this regard is to get into granularity, right, into principles or smaller units than just cases, right, because much of law happens at the sort of not paragraph level, but much more at like the legal principle level. So it's a very exciting time. I think I've always maintained that so much of this field turns on whether or not natural language processing can see the same explosions that we've seen in other areas of AI. One of the many ways that AI marketing and a lot of folks who do a lot of hype have done a disservice to folks is with this hand waving where they put up a slide about a self-driving car and then imply that, therefore, we're going to be able to quickly understand what a judge is saying, right? When in fact, those are very different areas of AI relying on different technology. And, the neural nets are currently the best chess players the universe has ever seen. Surrey is not the best anecdotalist that the universe has ever seen, right? So you can see that there's different levels of progress. Having said that, one thing if you take one note from me on all of this, BERT, B-E-R-T, which stands for, I believe, Bidirectional Encoding of Representations from Transformers, is a mouthful. But essentially what it's doing is it's letting natural language processing models train on a huge corpus, remember what it learned about the way English works, and then be tailored specifically to the common law, right? The common law is a relatively small body of work, 8 million cases, but compared to, say, all of English ever written and things like that. And one of the limitations that we've had in natural language processing is how do you train it with a relatively small corpus like that? Well, this development BERT came out last year, released by Google, is allowing us to sort of piggyback on things that were trained on huge corpuses and bring that into smaller corpuses. And the results are things like algorithms that when they see the text, these two holdings cannot be reconciled. For the first time now, I'm seeing algorithms that flag that and say, it seems like somebody's getting overruled here. Right? They don't speak like that, but they flag a value. Whereas previous algorithms looked for things like you'd have to say we overruled this case or this case is no longer good law. So it's a wonderful thing to see the progress in natural language processing, and I think it's paying attention to that will help you have the best gauge of where these tools are and separate the huge amount of hype from where we actually stand. Thank you.
So can I ask about BERT? Just a little bit?
Sure.
So within the context of using BERT, is that going to be just applying that to the small legal corpus? Is that going to be able to use the natural language fluctuations and be able to group them together? Mm-hmm.
So
analytically?
My understanding is it can be used for, and by the way, there are certainly many more qualified people to talk to about BERT, especially in the Bay Area. So please, take it from me to look into this and then find people that are much more expert at it. But yeah, absolutely. You can use it for document classification, right, to sort of join things and say, this is the case from, this is the underlying district court case that it corresponds to this appellate case. These are things that our brothers and sisters at Lexis have a huge army of people to help them do. But for startups like ours, it's useful to be able to have algorithms that can reduce the amount, not eliminate, but reduce the amount of human review.
Okay, thank you. Does anybody else have any questions that they'd like to ask up front right now as we move along? Okay. Michael, would you like to?
Sure. So, I mean, I think a lot of folks saw my story earlier this morning. Don't want to have to go through a whole 45 minutes review of that. You got the gist. I guess, I mean, today I'll maybe just focus a little bit more about what we specifically are doing today, because I did kind of touch on that during the talk, but I didn't really want to dive too much into it because I wanted to really talk about the broader subjects. But, you know, earlier I was talking about that we really want to put the power of data analysis inside of the librarian's hand, inside the in the attorney's hand, not just being fed data that is, you know, compiled by a publisher, but being fed, but by taking raw data that comes from the courts or comes from a variety of different sources, and then given tools to actually process that data themselves. So being able to being able to use tools as, I mean, simple as Excel, but imagine kind of like an Excel tuned specifically for litigation analytics. And that's what we're building right now. That's what we have built. It's called the Analytics Workbench. We won the Legal Tech Innovation Award this year, just a month ago, so that was really very, very exciting. But generally what it does is it allows knowledge professionals, librarians, data scientists to go through a set of dockets and extract information from each of the docket entries. So you can actually pull out kind of whatever, you can actually tag every docket entry inside of a docket sheet with whatever you want to apply. And you can create rules we can create many rules to actually apply those tags to the docket entry. So for example, this kind of comes up in, you know, if you have an existing analytics program that only analyzes 3 or 4 different types of motions, and this is what the publisher's given you, something that has like, okay, has motion to dismiss, motion for summary judgment, motion to exclude, and Dalbert motion or something like that, right? But then, you know, all of a sudden there's a motion for, give me a 5th motion. Preliminary injunction. Okay, yeah, anti-slap. Actually, anti-slap's good because that's kind of very specific and actually doesn't come up. It's common enough to come up, but it's not extremely common enough to be like the most obvious thing that someone would focus on. Anti-slap's great. So if let's say you want to make an anti-slap detector, what you could do is you could use the Analytics Workbench to create a set of rules that every time it sees, you know, this many words within that many words and not this many words within that many words inside of a docket entry, and that docket entry is more than two docket entries away from a previous docket entry, then apply the anti-slap rule, the anti-slap tag to that docket entry. And these rules can be as simple or as complex as you want them to be. And the beauty of what we're doing here is it doesn't require a bidirectional something. It requires just Boolean searching. And that's something that all librarians know how to use. It's very transparent to librarians because you've been doing it for 30 years now or more. I don't even know when Boolean search first came about, but quite some time. And you can actually create these rules yourselves and start analyzing the data. I didn't mean to go hard on Bert, man.
Bert's going to be just fine compared to manual tagging based on Boolean and how many docket spaces came in between the entries. Though I'm not worried about it. We're good.
Yeah, it's a very different context that to use to extract data. Like Bert is using kind of statistical models to pull out data, whereas this is basically allowing attorneys and research professionals to set up their own complicated rules in an organized manner. And the beauty is that it actually really does work when you're analyzing something along the lines of like 10,000, 20,000, 50,000 documents. And you can really build analytics very quickly and meaningfully on areas that no one's ever actually touched before. So you can build an anti-slap, litigation analytics yourself, even if no other provider is providing it, or any particular type of motion. So the general gist is you build up these rules, you get them to run on 2 or 3 different cases, and then we have these QA tools to help you run them on 40 or 50 cases and allow you to check to make sure your rules are working properly. And then you click the real run button, and then that runs them on all 10,000 or 20,000 or 50,000 or whatever many cases you want to run it on. And then we can visualize the results for you. So it's still the same steps I was talking about earlier: extraction, aggregation, visualization. It's done. The extraction part you can actually set up yourself. That's kind of the gist. And I guess if there's anything, any theme behind this, it's really about putting the power of the analysis inside the hands of the librarian or the actual people using the tool.
So are there any updates that you're specifically working on that you can tell us about?
Yeah, I mean, there's, well, for one, this tool's already out there. People are using it to create some really interesting analytics. I can go through a list of them, but it's what we're really seeing, though, is once, okay, like a lot of other companies out there, rightfully, I'm not criticizing it at all, but like, they come up with some analytics, and they're really nice analytics, okay? And they took a lot of time to actually build these things. And of course, they want to charge for them, right? With our system, but that's because those analytics they're custom created, like, in-house. It's like they're real mojos in those analytics. With us, we're just selling the tooling, right? So we sell you the tool to build your own analytics. Then you go and create your own analytics, you build them up, and then what you do with them is your business. If you want to just keep them in-house and just look at them yourself, that's fine. If you want to share them within your firm, that's fine. If you want to put them on the front page of your website, that's totally fine as well. And we provide interactive, we provide links that actually do not require passwords. So you can set up a link to this to your analytics. Anyone, they don't have to have a Docket Alarm account. They don't even have to know what Docket Alarm is. They can go and start using these analytics for free. And so once we have this set up and rolling, we want to create a marketplace of these analytics of people actually who are willing and able to share them, so that you can look up, for example, Kirkland and Ellis's, anti-SLAPP litigation, anti-SLAPP analytics, and then maybe you can build upon that and actually grow it and make it a little bit stronger. So we're the next step is to actually not just about building the analytics, but actually sharing them and making them more widely usable.
Can I ask about the Boolean logic?
Yeah, go ahead.
Is it true just standard Boolean, or is it wildcard operated as well?
Yeah, we have actually some fancier stuff than typical Boolean. So obviously we've got the and or not. We have stemming, so like you can do exclamation point and guess the end. We have another one that I think a few systems have, proximity searches that have like A within B, or let's say basket within ball, within one of ball, right? That will find ball basket. It will also find basketball, right? So we have another one that actually enforces order as well, which can be helpful. So if you just only want to find basketball, not ball basket, there's some extra things like that. Then we also have a number of sub-filters that can do all sorts of interesting things as well, especially when you want to start looking inside of documents. It gets very advanced. But we really don't try to stress the advanced sides of things initially. It's a very new tool. You probably have not, if you haven't seen it, you haven't seen anything like it. I can just put it that way, because other people have, analytics are relatively new, and building your own analytics is very, very, very new.
Thank you.
Can I add one thing just to emphasize why this is so important too? There's actually, among the people who know much, much more about myself than all of this stuff, is a guy named Chris Manning at Stanford, who basically runs the NLP group there. And there's a paper he wrote in 2010 called Legal Docket Classification, Where Machine Learning Stumbles. And the paper is basically this top-level NLP guy thinking, surely we can parse these dockets. Come on now. Like, look, it's a ledger, right? And then realizing, sort of descending into madness as he realizes more and more that without the domain knowledge, the things that you guys have, and that's where I think it's so important that what Michael's doing, what Fastcase is doing, putting this in your guys' hands, because you guys know about those small nuances and about the way that judges operate. And essentially what the conclusion of Chris Manning, granted this was 8 years before BERT, I don't know how BERT's going to impact it, but was saying basically without that domain knowledge, forget about it, right? And so I think that this is really the best chance to see some really advanced data science being done on these dockets, because you have it in the hands of the folks who know what they're doing.
Yeah, I think the domains are a little bit different. Like, we're not trying to solve the problem of 8 million documents with this. We're not trying to run analytics on all federal and state courts, period, right? We're trying to, you take a jurisdiction or a set of jurisdictions, you take a motion or a set of motions that you're trying to analyze, and then you can build upon it slowly and surely, adding more and more to it. But I think a tool like BERT might try to be doing a bigger picture type of solution where with the analytics workbench, we're looking at 10,000, 20,000, 100,000 documents at once. But, if you're looking at anti-SLAPP motions and you want to get a good sample size, 100,000 is pretty good. Even 50,000 or 10,000 probably will get you quite a lot, as far as you need. It's maybe just a different sample size or, different kind of way of looking at the data.
Does anybody have any specific questions for Michael before we go forward? Yes?
Well, in the age of Facebook and other operations that build upon what we're teaching it, are you taking what we are producing and learning from that and reusing it, or is that completely ours?
If it's private, if it's marked at private, we don't touch it, unless you ask us to. Or if it's, there's 3 options right now. We're going to probably expand upon this.
What's the default option?
The default option is private, okay? The default option is private, but there's right now private, firm-wide, and public. But right now, there's no unfortunately, I mean, there's the only sharing capability is copying and pasting a link. It's not like there's a searchable database of all these different analytics that you can look through. We're definitely working on adding that. But if you make it public, I think it's fair game for us to be able to look at it. If you do a firm-wide or private, we're not going to touch it unless we're supporting you in some way internally. So it's not like we're doing any fancy. We're not trying to like steal your data and build our own special data. Like it's yours. We're not even going to look at it. And quite frankly, we don't even know where it came from. So it's like we're not necessarily going to trust it.
So you're not location tracking for us for ad data?
No, you're not targeting. Yeah, you're not going to do an anti-slap motion, and we're going to, I don't know, send you. I don't know.
You could look at the IP address, right?
We could.
Here's our anti-slap journal from Full Court Press.
Yeah, exactly. Oh, I see. Well, hey, maybe we should do
Good
that.
idea.
So thanks.
Thank you.
Thanks for the suggestion.
Yeah, right? Although it's very possible that we could like throw relevant if you're searching for one thing, maybe once we start getting, hopefully we will start building a community of these. At least it doesn't have to be a public community, but I'm thinking more of like an internal firm community where like one librarian can more easily share their work with another librarian. Maybe then it can start moving externally and be more of a public one. But bringing it out, we're not in the advertising business, so it's not really our target.
Thank you. Anybody else? Carrie?
Thank you. So I'll just reintroduce myself. My name's Carrie from Ravel Law, and I see a few familiar faces, but just wanted to get a feel for the audience before I go back into the prehistory of our company. How many of you have heard of Ravel Law before? Oh, okay, well, cool. And how many of you have heard of Context from LexisNexis? Okay, so I guess I can go back to about 2012. So the company was founded around 2012 by 2 students from Stanford, neither of whom could be here today. They send their regrets. Our founder just had a baby on the weekend, so he's just started a little early paternity leave, so hence his not being here. But I'm happy to fill in. His other child is Ravel Law, which was acquired by LexisNexis, which is you can acquire a company in 2017 in June. So before the acquisition, our primary focus was on data visualization tools and analytics tools, judge analytics tools essentially, based on a corpus that we got from Harvard University's law library. And actually, that was my third question I forgot to ask it. How many of you have heard of the scanning and digitization project at Harvard? Okay. Oh, so I'm preaching to the choir here. All right.
You're talking to law librarians?
I just want to make sure, yeah. No imposters. That guy's here for a free sandwich, but oh, he snuck out. So, so we were working with one corpus. We had case law from the 50 states, some cool stuff, tribal stuff, and from territories, stuff that predated the United States, but a really comprehensive set of data that we committed to scanning and digitizing, then sharing with the general public. And in return for paying a bunch of money to Harvard for the project and supporting the project going forward, we would be allowed to build analytics products that we could sell based on that data. So for all of you, the core, I'm sure, of your careers is about being the stewards of the American legal system and having protecting that tradition of common law, making sure that it's kept accurate, that the laws that people are depending on are the right ones. So we thank you for that kind of work. What we've made our mission is to then look at that content and develop products that find insights that are hard to find by just looking at a book, by using a search engine, but rather by aggregating certain types of information about judges, about courts, about topics that come up in the law. And this is all based on, and this will sound kind of like an echo of what you just heard from my two colleagues to the right here, or two associates here, is that we use natural language processing and machine learning principles to do this. So there's really been a change over the past even less than a decade. 2010 is a good example of when things really started to take off. But applying technologies that just weren't possible without cloud computing, without just the processing power that exists today, and without some of the theory that's been applied. So we've taken come to modern history now. So move forward from 2012, go to 2017 June. Post acquisition, we've had all of LexisNexis's extensive content at our disposal. So we've been tweaking, and without tweaking now, really changing our approach to how we work with all of that data. We started around the time of the acquisition, we were sitting about 20-ish, maybe 30 employees, not counting contractors. With all the new content we're working with, there's obviously thousands of engineers at the company, and our direct team is close to about 100 people that we work with. So there's been a lot of growth over the past year and a half, repurposing people within Lexis to work on predictive technologies, and really just applying research and development that came that was new in 2012, 2014, and applying that to data that Lexis has had, depending on how you look at their previous acquisitions, like Shepherd's, over 100 years. So it's been a really, it was a bit stressful when we first got acquired because we didn't know what kind of freedom we would have within LexisNexis. Working at that company has, they've really opened the doors to what we can access, what we can apply our technologies to. And yeah, it's a kind of a new world in terms of the technologies on the horizon. So I'll remind you, I'm not a technologist at heart. I was an attorney, practiced as a litigator, as my wonderful bio that I wrote myself mentioned. But myself and a lot of, I'm sure law librarians, people who are here today, a lot of associates at law firms, partners at law firms, are seeing how you can really use this, use technology to find things in data that weren't there previously. So today, I'll kind of wrap this up, but basically today we've been looking at things like comprehensive news sources from everything. I won't call it names, but name a news source, and we've looked at how it can explain patterns in the case law. We've looked at internal documents with the permission of firms to see if there's relationships between litigation and events in either their documents or in public documents. And again, kind of extracting as much value as we can from the relationship between public and private sources of information. So a large portion of that team is also, that kind of 100 people I'm talking about, is working on predictive tools for looking at legislation. So obviously there's common law, but there's the statutes that are important in regulatory regimes. And so trying to find relationships and just insights within legislative data, lobbyist data, things like that. So that's been kind of a fun focus of late. So I think I'll wrap it up there. I wasn't too boring, and I'm happy to answer any questions. I think you're the moderator, so you take it away.
Do we have any questions? Within context of context,
Sure.
how is there any update that we can speak on?
Sure.
That's coming out?
Yeah. So I guess a bunch. How many of you are at law firms? Just curious. Okay. So I imagine many of you have used it in that context. I hate that pun. So the right now, so I'm the product manager for a feature that should come out end of June, beginning of July, called Court Analytics, which is very similar to Judge Analytics, but should include a compare function so that you can compare. We're just talking about this in meetings just before this. Citations in one jurisdiction to citations in another jurisdiction. So looking for trends and splits in authority, which cases tend to be most frequently cited in one versus another, doing some benchmarking. We've really been focusing on language. We have a sister company within LexisNexis that operates as an independent business, but with very strong relations, headquartered down in Palo Alto, Lex Machina. They've focused very heavily on docket information, on time to trial, on how long discovery takes. Really fascinating stuff. They've been around, I think, longer than Ravel has by several years. We've really carved out a niche in doing our R&D and now our productization on the citation and case law side. So we've looked a lot at the the text in those cases, trying to extract somewhat how Paulo was describing it, looking at the meanings in sentences, applying our senior data scientists tend to come from a linguistics background, so they're language folks, started off in linguistics, and as big data and all this cloud computing happened, kind of made their way over to machine learning because they're so heavily related in an NLP context. So yeah, so anyways, to get back to your question, most of the developments are in the kind of diving into the language, looking at company analytics, for example, which some of you may have seen some early marketing on that. Not yet released, it'll be a few more months, but looking at, say, stock prices to news information to news events occurring and how litigation events tend to be tied to those news, as I mentioned earlier. That'll be part of company analytics. And then looking at law firms down the line and attorneys, how they've moved from one firm to another. So we're hoping that'll be helpful for the careers of attorneys, in addition to being useful for corporate counsel who are analyzing the firms that they work with. It'll also be a good way for lawyers who've worked on interesting cases to highlight their experience and show that they've worked on hard cases. We're kind of drawing away from the idea of benchmarking success rates because it's somebody's winning 95% of their cases, but they're just representing banks in foreclosures against unrepresented people. 95% win rate doesn't really mean anything. Same thing as somebody takes really hard appeals to the Supreme Court. They could have a 10% win rate going against the government and still be a stellar attorney. So that's what's on the roadmap. Yeah.
Thank you. All right. Does anybody else have any questions for our panel?
I'm just curious, what's happening? I haven't heard much about the Harvard scanning project. Is that still going on?
Oh yeah. So yeah, I've been trying to hype that a little more. So we have been providing bulk downloads of the Harvard corpus to research scholars so that they can do their own research. We're planning a conference, kind of on short notice, but we're planning a conference at Harvard it's right after the the ICA, the AI and Law Conference in Montreal. So it's like second to last week of June, I think. There will be some publicity about this, hopefully. But yeah, we've thought, as we've focused primarily on productization of this data set, we've worked with Harvard to provide access to the same data to scholars who truly have a non-commercial purpose and sign a lot of indemnification agreements and get people to back them up. But we basically, they until 2024, Ravel Law and LexisNexis have a proprietary right to productization of the data. So it will be opened up in a few years. But we
Which is a huge tragedy given all the OCR problems with it. We can't really use it commercially, but you could certainly do a lot of big data analysis on it.
Yeah.
Could we get a little controversial now? Are you guys up for that a little bit?
Oh, boy.
Oh, we're open to that.
Are we okay with this? Okay. So, with respectfully, I think that what Lex Machina has done with dockets was fantastic, right? Where should we bring this suit, given that we can bring a patent infringement suit anywhere, right? I think that the attempt to bring that approach to the specific language that judges use has oscillated between the bleedingly obvious and the statistically irrelevant. And I submit to you guys that judicial analytics, as applied to case law, is like phrenology. It is like the people that used to say, I'm going to measure this skull and tell you whether or not this guy's committing a crime or not. It's not that things aren't being measured. This was the thing with phrenology. Things were being measured. They had a ruler out and they were doing things. It's that the things that they discovered from those measurements were not nearly as actionable as the people, purporting to offer that service said they were. And I have yet to see, and I challenge anyone in this thing to show me these concrete examples of where this actually is paying off in some way, where these insights. And in fact, it leads to very cartoonish situations, like a reporter for the London Financial Times reporting on context, saying that this judge's favorite case is Anderson Liberty Lobby. He just loves it, right? No, he does not. He cites it because it's one of the major cases about a standard civil procedure, right? And
It's like Twombly.
I think that, and please do. Twombly, Celotext, right? You can name all the top ones. They all appear. And then if you take a step back, it's like this judge of the Ninth Circuit has a tendency to cite to the Ninth Circuit. You see that emerge out, right?
No way.
Of course, if you want to go granular, then it's, well, this judge cited to this paragraph 3 times.
Interesting.
Not two. So maybe it's the best one to use for the arguments. Maybe it's the best thing to use for our context. But what about that statistically irrelevant difference over there that we saw with our gadget? I think that I'm a huge fan of what context is doing for the expert witnesses. I'm a huge fan, it sounds like, of a lot of the different things that they're doing. It is not that I am against using data-driven systems where appropriate for strategy. But I think it is absolutely farcical the way that they are now marketing this thing as somehow knowing the best argument to make to your judge because you've analyzed the statistics and done it like that. I have yet to see a single example of that in any real way, and I don't think anyone should encourage it. And I say that with complete respect to my colleague Carrie, who's been working in this field with us, for now 10 years. I think there's a lot of great things going on. I think that is not among them.
Do we have a
I wish it
rebuttal?
would all go away. Okay.
And if the gentleman from Palo Alto would yield his time.
So yielded, yeah.
I believe we've conceded time, and we're going to go ahead and next. No, I'm kidding.
Thank you, Chair. There's a good example. There's actually, when I first started working at Ravel, there was a specific use case that this is when Judge Analytics hadn't become a product yet. It was still kind of an internal MVP. In fact, it was thought up in part by an engineer who just thought, oh, well, look at one thing we can do.
Exactly.
And then, right. and then the use case emerged. And so the one that I would think of, and forgive me, it's been a few years since I practiced in the Eastern District of California, but I was working up in Sacramento, and we would deal with a lot of 12F motions. And I've probably used this in a demo for somebody here, but we deal with a lot of motions to strike affirmative defenses from our answer. And so it was really, often when we were dealing with what we considered to be plaintiffs who were trying to waste time, drive up, in, say, a civil rights case where they're trying to get attorney's fees paid for, things like that, they would file these motions in an attempt to just draw things out a little bit, drive up the fees, and we would look for kind of a strategy for fighting these 12F motions. What we found is that the standard applied in the Eastern District of California by some judges differed from other judges, that the Eastern District had a different posture compared with San Diego, with the Southern District of California, and that the specific cases that were cited by particular judges differed depending on their posture. And so by filtering down, starting with the opinions authored by, say, the Honorable Judge Mueller in Sacramento, and comparing, say, to Judge Burrell, you would find differences in when looking at 12F motions. You would find that one judge cited one line of cases that seemed to require to accept any affirmative defenses, and at least at that stage, and to eliminate them later, and others who said, no, this is not, and forgive me for those of you who work at the state courts, but this is not a state court proceeding. We don't allow you to throw a laundry list of 100 possible affirmative defenses onto a pleading and reserve the right later to deal with it. It has to have some kind of relevance to the pleadings. So we would use that without the technology that we have now with Judge Analytics. We had Excel files where we tracked which judges were more favorable, more amenable, and which ones weren't. Same with looking at grant rates for, say, 12B motions or Rule 56 motions, motions to dismiss, motions for summary judgment, on the same issues when we narrowed down by a particular topic area, whether they would grant or deny a motion for summary judgment early on. So there are, I respect everything you've said, Paulo, but there are statistically significant differences based on our PhD linguists / statisticians between the grant rates on the same exact topics in the exact same court, and you'll find a big difference between judges. In fact, across the country,
same factual background, right? Of course,
with similar factual backgrounds. So there are strategic uses and tactical uses.
But tell me, Carrie, you don't get to choose your judge. So when you find that your judge happens to be a 42% grantor instead of a 51% grantor, what do you do then?
Sure. So
We can't do motion.
there was So it was a question
you won't
of
move for summary judgment based on a. I mean,
you could motion to exclude.
right. So that's a good example. It was often in the context of litigation. You're often working within a client's budget, for example. You are trying to plan settlement negotiations, trying to decide how much of the junior associate's time should be poured into, say, a Rule 12 defense versus into something else like getting on with discovery. So in a world where there are costs involved with litigation and where you're trying to do some business development, keep your clients happy, we did find use cases for this.
I mean, I was just running analytics yesterday on New York civil cases, and we found for preliminary injunctions in New York that judges ranged from granting them 2.9% of the time to 57% of the time. And these are all judges that have seen over 30 preliminary injunctions. So if you're going to go in front of a judge, I think the 2.9% guy, it was like 1 out of 39, whatever that math is. So out of 39 cases, he granted 1 preliminary injunction. If that's the case, and you bring a preliminary injunction, you better be telling their client
And
that you might be wasting money.
Parsing, that's what I mean. You can parse dockets to
Yeah.
get a sense of that stuff. That is not going in and saying, you know
Fair
what
enough.
really makes this judge just feel so persuaded is when this paragraph is chosen or this case as opposed to this other one is cited. I completely agree with you. There are judges with different temperaments for sanctions, for things like that.
Right.
But my only objection is actually quite more narrow than this, but unfortunately because Ravel was set up with all the case law, so they're like, well, let's just do this, right? The idea that you're choosing what paragraph or what argument you're going to make specifically within that context is where I think it all falls apart.
So the placating language towards a specific judge versus using the specific language because it is good law or good usage
Exactly.
is what you're arguing
I think
against.
that's where it falls down.
And that's, again, I'm sorry, we'll recognize you in just a moment. Allow me sure.
So one of the things that happens too, I think within a law firm, I think a common experience is whenever you bring in a product like this and you show it to an attorney, the very first thing they are going to do is run something that they know, and it's usually themselves.
Mm-hmm.
And
Absolutely.
I'm curious, what do judges think? Because I think everyone here has a piece of the facts here, or the truth that's going on. What do judges say when a product is marketed to say, look, this will help you?
I was on a panel with one.
Can I actually interject? We actually have Donna who has something to say about this.
We've actually had judges and we've showed them this, and they're like, why would anybody need this information? I mean, they were dumbfounded.
Great.
Also, you have to keep in mind, like at the court of appeal level, they have and at the Supreme Court, they have a staff of research attorneys who are actually writing the opinions. They author it, but they're not writing the opinions. Some judges do.
Oh,
So
thank
our,
you for that. You're right. The changing clerks, yes.
Writing of the research attorney, not the judge. Well, they sign off on it, but they were all dumbfounded. I've talked to several judges who, like, why would you even use that?
we've done research as well on, yeah.
Are
Okay,
you
so
talking
let's
about- are you
never
talking
speak of
about-
it again, everybody. Do we all agree on that?
I agree. I think that all of the judges' official stance is that they rule on the law and they are correct. Yes. Why would anyone need this? Because, you go in and if they just clearly are making the correct decision.
So we hire their clerks, these research clerks. Our lead designer, for example, on the Context product now is a former clerk at the California appellate level. So she was a research pool clerk. Excuse me one second. We've done our research on that. We've talked to judge. I won't name the judges because I don't want to feel like we're endorsing them. And I've heard some of the same, which is we rule on the law. What we've noticed is informally in these conversations, they've especially those who kind of really dove into it, liked it. They didn't feel that it was a report card on them. They know that they're not vulnerable to the technology telling them that they grant slightly more, slightly less than other judges, but that they liked the idea that people would come into their courtroom knowing in advance how they had ruled on previous issues, that they were going to attempt to be consistent with the principles of common law, stare decisis, of consistency generally, and they liked this. So being able to say, yes, I cite this case frequently for this purpose in this topic of law. I'm planning to cite it again. If you bring that up in your brief, that's going to be something that I want. you to do, and you're not going to bring a frivolous motion because you know you're going to get a Rule 11 sanctions against you. So that's been our experience.
Yeah, I've actually got a similar set of experience, but just to clarify, we are talking about kind of two different things here. One is like how often a motion is granted overall, and then the other one is kind of what type of reasoning or what type of cases they cite to. And so there's different different. Overall, you're kind of still trying to get at chances of winning and statistical analysis of litigation. But I actually was on a panel, so I do the former, meaning just kind of like analyze the likelihood of winning just overall without digging too deep into the cases that are cited, because there are large discrepancies in them. But I was on a panel much like this, but there was a judge. It was actually at a patent convention. And the judge kind of gave publicly the judge gave exactly the same spiel. Like I was like, we decided cases that come up to me, and I had all these slides showing this disparity of judges, and then they had like completely stone faced, and I was trying not to be too much of a jerk, but it kind of probably was, and then afterwards like they walked off, and then like we chatted at the end, and it was like, let me see my stats. So they all looked them up, and actually one of them, there was two of the judges there, and one was like completely like right in the center, like as boring and straight shooter as you can get, and the other one had was kind of off to one side on one particular thing, and then you could see them getting into like not an argument, but like the one who said it was off was like, well, yeah, that's the right way of doing it. Everybody else is wrong, So it's just because one is one way versus the other way doesn't actually make them wrong. They sincerely believe that there is reasonable minds can disagree on these things. Reasonable minds can disagree if preliminary injunction should be granted.
Not on the part I'm talking about. I'm moving for summary judgment on this. No reasonable jury. On the things you're talking about, I think we do agree that it's useful, but no.
I'm looking at overall statistics of granting and denying quasi-discretionary decisions like preliminary injunctions, which have a lot of discretion in them, decisions like summary judgment is a little bit weird because oftentimes they can punt. So granted summary judgment is kind of a very strong loaded thing, but a lot of judges just deny summary judgments because they like trial, okay? And that's the main reason. And that's much more of a discretionary type of matter that gets involved. Appellate courts are a different ballgame altogether. We haven't actually messed with them that too much because there's much less discretion. It's based on the law.
Thank you. Do we have one? Yes.
Sort of changing tacks. I have a question regarding access to the raw data. And there are still a number of counties, even in rather rich states, where there's no electronic dockets. The trial court orders are not available. So I want to ask each of you, what are the gaps in your product? Santa Barbara.
Do you want to go first? Alexis says, I'm all set, thanks.
Sure. So
Talk about it all day long.
That's a very long list.
yeah. So we started without the Harvard data, and we decided to use public Supreme Court and stuff from Google, basically. We got the Harvard data. That was just published opinions. Once we were acquired by LexisNexis, we had access to a lot more trial court data. And one of the huge advantages we have now is that that in many ways, LexisNexis also considers itself a content company and has a huge initiative to supplement trial court documents from around the country. So much of the technology that we're building for Context, which is a core product that we've been talking about, while we build that infrastructure, we do that with an eye towards what content will be coming in over the next few years, even the next few months. High priority jurisdictions that don't have much high stakes litigation, but happen to be underserved by other products, things like that. So there's a whole wing of the company, much bigger than our product development group, that's focusing on just gathering content and pouring it in.
Actually, one thing that's not actually a jurisdiction, but I think is quite relevant content that could be much more easily freed up, just by nature of the fact that we've only had two major legal research platforms for decades, courts will often require there to be a Lexis site or a Westlaw site, right? The WL space number or the capital Lexis number. And the truth is that these two companies, I believe, share that information only with each other, right? Westlaw has all of the Lexis sites and Lexis has all of the Westlaw sites. Surely you guys would agree that this information could be easily made available to the public so that companies like myself and Mr. Stannard could benefit from it. And then, in fact, there's nothing original in that numbering, and it's simply it's encrusted that this is used, but it really doesn't need to be. Would anyone disagree with that? Okay, Carrie, will you get on that, please? So you're going to go back and say, he called us phrenologists and then said he wants the Lexis sites. This guy, you know,
Right.
he's got
So-
some nerve on this guy.
I can find the areas that we can definitely agree upon. Areas that I think it's very difficult to get data, not as a practical matter. It's actually, but federal courts, obviously, PACER is a huge problem. He mentioned Lex Machina, and they spent an enormous sum of money. I think I brought this up earlier. An enormous sum of money just on PACER fees. And I know that the AALL is involved in legislative affairs, and it would be, and there are bills pending on the Hill right now that are going to move slowly, and we'll hopefully get them, passed in 10 years or something. But that's the type of thing that would actually open courts up quite a bit, and that's federal courts. And the really important thing about federal courts, it's not just that they cost a lot of money, but they're the leader, right? All the other state courts are going to be looking at them. The reason why courts in California, like in Los Angeles, Sacramento, San Diego, Orange County, charge access for documents is largely because the federal courts can do it, and so they think they can get away with it too. If they were free in the federal system, they probably would be a lot more pressure to have them free in these other counties. And it's not just in California. There's plenty of other counties. Florida has a lot of paid court access. New York has some. There's a lot. And then, of course, then there's the... Texas has some. Yes, Texas has some counties. The main counties actually are free, but a lot of them are not. And then there's, of course, the counties that just have nothing, right? Or just have the docket sheets without the documents. There's a lot of counties that just have that.
Yes.
Which tells you the docket sheets are definitely better than nothing, but the documents are a lot more.
And I should point out on the topic of citation, we've been working with Harvard on the Perma CC stuff as well. So there's the Harvard Innovation Lab, and they've been doing a lot of archiving work for a permanent digital repository for legal citations. So there is an initiative there. It's not coming from within Lexis. We certainly have reasons to want a Lexis site gets you to our documents faster, but the world's changing. That's coming, I think. So.
Thank you.
And sorry, there was a question I cut you off.
We have time for one more question.
We're already out of time.
And do
That's so much
we
fun.
have a hand? Anybody? Up back?
So, I'm curious if cost is not object that can you see each other as adjuncts that you would subscribe to all three of you? Or do you see yourselves more as the competitive edge that one of you will have the key approach that will become the essential for our research?
And for the camera, I'm going to reiterate, are you guys friends or foes?
Right. So I would turn it back to you a bit. That there's I'll fight you. No. Just kidding.
Brothers.
I think that librarians and folks in research and knowledge management and all that are really the gatekeepers to these technologies. That it's going to be basically your job to know what's good and what's not, to really do your due diligence, and that I suspect, much like we're held accountable on the quality of our products and our business strategy, I think librarians are going to be held accountable on what they let in the door that they shouldn't have, and at the same time, what they didn't let in that they should have. And so that I would encourage you to test all of our products to see what's working for you and what's not, because I think a huge competitive edge is going to come from applying these technologies to legal research. It's going to make a huge difference to law firms and to the clients, and you guys really are the gate. So.
Thank you. Does anybody have any last remarks?
Well, I might just an answer to that and actually just say something quite nice about Lexis too, which is that, the truth is it takes a lot to be a full-fledged legal research engine, right? There's a lot that goes into that if you're the only thing that people are using. And certainly tools like Kara, we market it as filling in some blind spots that existed, right? Because we do certain things with citation graphs and things like that. Increasingly, we're trying to build out a full research engine that does everything that you need. And truthfully, we do think we can do every single thing much better. But I will say that a huge amount of work and time and effort and money goes into creating both Westlaw and Lexis. And I think that the startups that are existing right now would be remiss to pretend that they sort of have traveled all the way to being that full system. So wherever we end up, I think where we are right now is it behooves us to build tools that are quite useful and provide functionality that you don't get from Westlaw or Lexis.
Yeah, I think that's right. I mean, generally, think if you were running a startup, would you want to do exactly what Lexis and Westlaw are doing, or would you want to find the things that they're not doing and do that, right? So we kind of design our companies in this way.
Well, thank you. And I'd want to thank our panelists for coming and spending some time with us. Thank you so much. And thank you for everybody for joining.